Good morning, everyone. My name is Shannon Sullivan, and I am a Deputy District Attorney with the Marion County District Attorney's Office. And I am here today to talk to you about court, about testifying in court, and to hopefully give you some helpful tips to prepare for your court testimony, and then also what to do when you are in the courtroom. So before I jump into that, I did just want to introduce myself, give you a little bit of background about myself, and then we'll jump into the PowerPoint that I've prepared that will hopefully be helpful as we walk through this. So as I mentioned, my name is Shannon Sullivan. I have been a prosecutor now for actually almost 14 years exactly. It'll be, I think, 14 years this month is my anniversary. I actually started my prosecution career down in Southern Oregon in Douglas County. So the Roseburg area, south of Eugene, if you're familiar with that. And I actually worked in that office for 10 years. I started as what I call like a baby DA, kind of handled, the basic introduction type of cases, your Deweys, your thefts, things like that. And then I worked my way up to person crimes. And so in Douglas County, I was on our major crime team. And so I focused primarily on homicides, person crimes, including, robberies, sexual assaults, and child abuse cases. After 10 years in Douglas County, I was fortunate enough to be offered an opportunity to go and work with the Oregon Department of Justice in the Criminal Justice Division. And so I moved up to Salem and took that position. And in that position, I kind of continued my role as a prosecutor that typically handled person type offenses. So in that position, I got to travel the state, and I went all over the state to places that I would never have gone to if I hadn't had that job. For example, never had heard of Fossil, Oregon, but I have spent now a lot of time in Fossil. And so I got to travel the state and would step in and help district attorneys' offices on the more complex cases or if they had a conflict. But again, I focused primarily on the person crimes, so homicides, and the sexual assault and child abuse cases. After being at the Oregon Department of Justice for a year, I then got a phone call out of the blue from Marion County, and they asked if I would be interested in coming and working for them. And I decided to go back to a district attorney's office, mostly because I really missed being part of a community. As much as I enjoyed traveling the state and seeing different parts of the state and working with different offices, I really missed that feeling of just community and knowing my community partners and really having that team type mentality. So I jumped at the opportunity and came over to Marion County. And I have been with Marion County now for actually almost 3 years. Time flies, I guess. In Marion County, I am on our child abuse / sexual abuse team. So I primarily handle cases involving child abuse, both physical and sexual, and then our adult sexual abuse cases. I also continue to handle homicides and other types of offenses, but my primary focus is sexual assault and child abuse cases. So that is why I am so honored and thankful to have this opportunity to come and speak to you, because so many of my cases involve SANEs, and I could not do my cases and my prosecutions without you and without your help. So I am so happy again to be here. Thank you for having me, and thank you for everything that you are doing and for sitting through this training. So with that, then I am going to start the presentation. I am going to share my screen. So give me one moment to get this pulled up. And so again, as I stated, I am here today to just talk about court and talk about what to expect from court, what's going to happen in court, and to hopefully give you some helpful tips that will get you through the court process. When you are called to testify in a case, you might hear the prosecutor or maybe even the defense attorney refer to you as an expert witness. And I want to talk about that for just a little bit. I don't want anyone to get freaked out or nervous when you start hearing expert and you're being called as an expert witness. And what does that mean? Really, it doesn't really mean anything other than you are being called as someone who has specialized training or experience. So if we refer to you as an expert, all that means is that we're recognizing that you have training and experience that the rest of us don't, particularly our jurors. I will tell you that many times in court, you might not actually be called an expert witness, and there's a lot of legal reasons for that. But just know that you are really being called as a specialized witness, someone who has that specialized training that is really there to help educate the jurors. So what can you talk about? If you get that subpoena and you're asked to come into court and testify, this is the number one question that I get all the time. What are you going to ask me? What am I going to be asked by the defense attorney? And what I tell everyone is, again, don't worry. You're not going to be asked a ton of crazy questions. Really, your focus is to talk about the particular victim that you did an examination on and the things that you observed during that examination. So really everything that's contained within your report, that is going to be the focus of your testimony. Of course, there are going to be times where you might be asked some more generalized questions, and I'll talk about that a little bit later on in this presentation, but just keep in mind, if you are called as a witness, what you are going to be talking about is that exam and nothing else. So don't panic. It's all going to be in your report. You're going to have it there. I promise. It's not going to be that bad. Again, you're going to talk about the exam. You're going to talk about the victim. You're going to talk about the things that you observed, you heard, the things that you did. One of the biggest things that you will be asked to testify about are going to be the victim statements that were made during the exam. I am going to touch on this in a little bit more detail later on in the presentation, but just know that this is such a huge help for the prosecution. Many times in court, without getting into all the legal stuff, we cannot have witnesses such as yourselves testify about what people told you because that's hearsay. And those people actually have to come into court and say what they told you. But there are exceptions. We have some exceptions when we're dealing with child witnesses, and we also have exceptions when we are dealing with victims, in particular victims that are going through a SANE type of exam. Again, I'm going to skip the legal stuff. If you really want to know, you are always welcome to reach out to me and I can help explain this in a little bit more detail. But there is an exception made for when a victim makes those statements to you during that first portion of your exam, because the court recognizes that those statements are being made for a medical purpose. And so therefore, you are going to be allowed to talk about those statements, which again, I just cannot emphasize is so helpful in these types of prosecutions. So let's kind of take a step back then and talk about when you might actually be asked to testify. There's a couple different parts of the court process that you could find yourself testifying in. The first is going to be grand jury. And grand jury is what I call probably the least stressful and an informal type of appearance. But so let me explain what I mean by informal. When you come and testify in the grand jury, you are going to be testifying in front of a group of, it's usually about 7 citizens. So these are people that are selected from the community. They get a summons just like regular jury summons, and they're asked to sit on our grand jury panels. Every county does it a bit different. Here in Marion County, for example, our panels stay with us for 2 weeks. And so they come in, they kind of have a rotating schedule, and then they just hear, case after case for those 2 weeks while they're with us. Their role as grand jurors is not to decide whether or not the defendant is guilty or not guilty. They are only there kind of as a check to make sure that the state has enough evidence to keep the case moving forward. So anytime we, meaning the state, the prosecutors, file a felony charge, we have to present that case to the grand jury. And again, it's really just for them to make sure that we are proceeding on cases we actually have evidence for. So you'll walk into this room if you're asked to testify in grand jury, and there'll be, like I said, a group of about 7 people. The grand jury is recorded, so you'll see computer monitors and things like that, but it's just, you don't have to worry about that. They'll take care of all of that, but it is recorded. And you're going to come in with the prosecutor, and it's just going to be you, the prosecutor, and the grand jurors. The defendant will not be there. There will be no judge. The defense attorney will not be there. And it will not, sometimes, lots of times it's not even in a courtroom. Like, again, for example, in Marion County, we have a separate room that we use in the courthouse that is not a courtroom. So that's what I mean by more informal. It'll be a little bit more relaxed. And what'll happen is you'll come in, you'll have a seat, and you'll be sworn in. And then the prosecutor is going to walk you through your testimony. So again, you're just going to be asked about your exam, the things that you did, the things that you saw, the things that you heard. At the end of the prosecutor's questions, the grand jurors are able to ask you questions as well. So you might have some questions from them. The prosecutor will let you know if it's okay to answer those questions. And then once your testimony is done, then you're done for the day. This is typically a very quick appearance. Once you get into grand jury, your testimony will likely be 10, maybe 15 minutes. but it'll be very fast because again, we're not in the trial. We're not arguing the case to the jury. We're just trying to show the grand jury that we have the evidence needed to move the case forward. So once that process is done, what happens then is the grand jury will tell me, the prosecutor, whether or not I can move forward with the case. So assuming that they do, which is typically what happens, but not all the time, but typically in these cases, that is what will happen, then the case will move forward. So the next time that you might get a subpoena to come in and testify might be at a pretrial motion. I will tell you that in my experience, this does not happen very often. So I don't want anyone to stress too much. It does still happen from time to time, but it is rare. But if you get a pretrial motion subpoena, again, what is going to happen is you are going to be asked to come into court. And this time, what's probably being litigated is some issue that we want to take up before trial. So maybe the state is trying to get some evidence admitted and we want to deal with it before trial, or maybe the defense is actually trying to get evidence excluded. So again, we're going to be dealing with that before trial. So this type of hearing is going to be more formal. This time we are going to be in a courtroom. There will be a judge, the prosecutor will be there, and then there will also be the defendant and his or her attorney. This appearance will not have the jury because again, hopefully this is happening pre-trial because again, we're trying to just figure out what evidence is going to be admitted at trial. And so what you'll do is you'll come in and again, you're going to see those people sitting at the tables when you walk in. And this time you're going to be asked to come into the courtroom. You're going to walk up to the witness stand. You'll be sworn in. And then it's going to be kind of the same process. The prosecutor will ask you questions first. And so they're going to walk you through the testimony that they need you to walk through. And once they're done, then the defense attorney will have an opportunity to ask you questions. In a motion hearing, also don't be surprised if the judge asks you questions. Many times the judges will also ask questions as we're going through this process. Typically, what you will be asked to testify to, again, is just going to be your training and experience and your exam, what you saw, what you heard, and what you did. Please, please, please feel free to reach out to the prosecutor before any type of hearing like this. In fact, the prosecutor should be reaching out to you, but we all know things happen. Our schedules are horrendous. And so if you're not hearing from your prosecutor, reach out and just say, hey, can we set up a meeting? I just want to make sure I know what I'm talking about. But again, you're probably just going to be asked to go through your training and experience and your exam because there might just be some issue. Maybe the defense attorney is trying to argue that you're not qualified to testify as a SANE. Or maybe they're taking issue with something that was written in your report and they want to try to keep it out. Just talk to your prosecutor. They're going to be able to tell you what the issue is, and they're going to walk you through the testimony that you need for that pretrial motion. So once that motion hearing is done, the judge will make a decision on whether or not that evidence is coming in at trial. So again, just talk to your prosecutor. They're going to let you know what happened at that hearing, and then they'll help you prepare for the next appearance that you might have, which is going to be the trial. So trial is the one that everyone probably thinks of when you think of having to come to court. And I will tell you, it is probably the most stressful and scariest type of appearance that you will make. But again, I don't want anyone to panic. This is not a horrible thing. You're going to get through it, I promise. But just be prepared and just know that it will be a little bit stressful. So trial, as you can probably already gather, is the time then when we're actually presenting the case to the jury or to a judge. Remember that a defendant always has the right to waive jury, and he can say, no, I just want the judge to decide this case. Again, your prosecutor is going to be able to tell you which type of hearing it's going to be, but let's just assume that it's a trial. Or a jury trial, excuse me. So when that happens, when you walk into the courtroom, what you're going to notice is there's going to be the prosecutor, there's going to be the defendant and his or her attorney, there's going to be the judge, and then there's going to be a whole box of 12 people, and that is your jury. And the jury is there to decide guilt or not guilty. This is the type of hearing where it will probably be your longest appearance. Not only will you have to wait in the hall before you get called in, once you get on the stand, this is where you will be on the stand probably for a little bit of time. I don't want to guess. I mean, it's really going to depend on the case, but just be prepared to be up there, for half an hour to an hour. what'll happen, and I'm going to go through this in a little bit more detail later on, so don't worry if you have some questions. But what's going to happen is, again, the prosecutor is going to start. They're going to walk you through your training and experience. They're going to walk you through the exam that you did on the victim for that case. And then the defense attorney is going to have an opportunity to ask you questions as well. This time, the judge will not ask you questions, or at least they shouldn't, but things happen. But typically, it'll just be the attorneys. Once the defense attorney has finished his or her questioning of you, the prosecutor is going to have another opportunity to talk with you. So that's what I call kind of the time for us to clean up anything that happened on cross. Once that part is done, then you will be excused and you'll be able to leave and go on with your day. So again, I'm going to talk a little bit or in a little bit more detail about some of the specifics of your testimony, but this is just a general overview of the types of hearings that you might be asked to testify in. My best advice is if you get a subpoena and you just have no idea what type of hearing it is, just call your prosecutor. We are here to help. We want to help. You are not bothering us. Please call and we'll tell you what's going on. So let's talk about testimony then and how to prepare for your testimony. And honestly, great testimony starts with great charts. The best advice that I can give you, and I give this to law enforcement, I give this to anyone who has to testify, is write it down. In that moment, when you are with that patient, when you are in that exam, write it down. Because I guarantee you, if this goes to trial, it is not going to be a month later, 2 months later. It's probably going to be 6 months to a year, sometimes even later than that. And by the time you get into court on this particular patient or victim, you are not going to remember it. You are going to have done hundreds of others since then, and it's going to be hard for you to kind of remember the specifics. So always, always, always chart everything that you can, because it's only going to make your life easier, 6 months to a year down the road when you actually have to recall this examination. Be descriptive. Write down, the description, of the patient. How are they acting? How are they presenting? Anything that you notice about them. Injuries, be as descriptive as you can with any injuries or markings that you are seeing. Just anything that is sticking out to you during your exam, just write it down and always think to yourself, what's going to help me remember this in a year when I'm having to testify about this? The more detail you put in your chart now, the easier it's going to be for you down the road. I'm a big fan of diagrams. I'm a very visual person. So if you're like me, draw a diagram, make yourself notes, whatever it is that you feel comfortable putting in that chart, just remember it's going to be there for you in a year when you have to go back and recall this exam. Quotations. This is probably the biggest one, the one that I would ask you to focus on probably the most. When you are with that patient and they are talking to you about what happened to them and they're talking to you about the assault or just, anything related to the perpetrator, it is so important to try to put down as thoroughly as you can any statement that that person is making to you. That is going to be so helpful and powerful later in trial. And again, if you can write it down at that moment, it's going to be in your charts. You're going to be able to testify to it. You're going to have your charts in front of you when you testify. So again, just write down anything that sticks out to you. And my best advice is just think to yourself, what's going to help me remember this in a year when I've done hundreds more of these exams and I have to remember this particular exam. So when you do get that subpoena and you are preparing for court, preparation is the biggest thing. Please do not think that you can just wing it. Please do not think that you're just going to show up the morning of trial, be handed your report, and you can just, read through it as you're up on the stand. I mean, could you? Yeah, I guess you could, but it's not going to be effective. It's very obvious to a jury when a witness is not prepared. And so I always take extra steps to make sure that my witnesses are prepared. And that means I'm going to meet with you before trial. I'm going to show you your chart. I'm going to have you read your chart. And then I'm going to probably have you read it again the morning of before you get up on the stand and actually have to testify about it. I also tell people this, though. It's not just me and me wanting you to look prepared. I know just from my own experience that the more prepared you are, the less nervous you're going to be. So no matter how prepared you are, when you walk into that courtroom, it's going to be intimidating. You are going to get nervous. I guarantee it. I've been a trial attorney for 14 years. I still get nervous in trial. You know, you're public speaking, you're in front of a big group of people, and this is a big deal. It's okay to be nervous. I want you to be nervous, honestly. But I also want you to know that once you start talking, if you are prepared and you know what you want to say and what the prosecutor is going to ask you, I promise you, your nerves are going to go away and you're going to get into like a rhythm and you're going to be able to catch your breath and you're going to be fine. But again, that's not going to happen if you're not prepared. So you need to review your reports. You need to meet with the prosecutors and you need to ask questions. There are no dumb questions. I want to know if this is the first time you're testifying in court. I want to know if you are scared to death about having to come in. Please don't think that you have to hide that or like act tough in front of the prosecutor. Please don't do that. Just let us know what your concerns are. Let us know things that are making you nervous, and we're going to help you walk through that. One of the hardest parts about court is the waiting game. I always joke with people, my job is really just a hurry up and wait kind of job. And I spend so much time myself sitting in a courtroom or sitting in the hallway waiting for my case to be called. And it's no different for witnesses. I can tell you for me personally, I do my best to try to limit the amount of time that my witnesses are waiting in the hall, because I know that that's even more nerve-wracking sometimes than being in the courtroom, because you're just pacing and you're just waiting and you're like, when are they going to call me? Am I going today? What's happening? I know that. So I always try to give you a couple hours, I guess, like of a time block. I can never predict exactly when you're going to be on the stand. I try to tell my witnesses, I think you're going to be on Wednesday morning. So I'm going to have you show up at 8, you know, and I'm just going to need you to hang out, but hopefully I'll get you on the stand before lunch. Sometimes it happens, sometimes it doesn't, but please just know that even if your prosecutor is trying really hard to come up with a schedule and stick to the schedule, once we get in a courtroom, I mean, everything's just kind of out the window and we're really kind of at the mercy of the judge and the jury and how things are moving. And it really just depends on the case. So what I tell everyone is I'm going to give you a time estimate of when I think you're going to be on the stand, but just know you're probably going to wait in the hall. So bring books, bring magazines, bring work if you're able to concentrate on work. That is not a problem. Bring something that you can have with you in the hall, though, to keep you just preoccupied, distracted, so that you're not just sitting there like pacing the hall, kind of freaking out, wondering when you're going to testify. I will tell you, because if you're like me, you carry your cell phone with you everywhere. Talk to your prosecutor before you come to trial. Some courthouses do not allow witnesses to bring their cell phones with them. So that might just be something that you want to find out ahead of time. Many times you'll have to leave them at security, or you'll just be asked to take it back out to your vehicle. I mention this though, not only because I don't want you to get stuck at security having to fight about what to do with your cell phone, but I also tell people this because if you can't bring your cell phone, I want you to be prepared for that so that you're bringing other material with you. Because if you're like me, I just have everything on my cell phone. And if you were to take that away from me, I would be like, oh, wow, I have nothing to look at. I have nothing to read. So talk to your prosecutor, ask if you're going to be able to bring your cell phone into the courthouse with you. And if not, then just plan for that. One little caveat I will make though, since we're on the topic of cell phones, if you are able to bring your cell phone into the courthouse, please know that as soon as you walk into that courtroom, you need to turn your cell phone off. Do not have it on silent, don't have it on airplane mode, just turn it off. There is nothing that infuriates judges more than when someone's cell phone goes off during the middle of trial. Trust me, I've been there. It is not pretty. So please don't do it. If you have your cell phone with you, just train yourself, turn it off when you walk into that courtroom and you'll be fine. So let's talk then about what's going to happen when you actually get up on that witness stand and you are testifying. These tips are really designed mostly for jury trials, but keep in mind that these are tips that you should be using for every type of appearance that we just talked about: grand jury, motion hearings, and trials. It's really important to do all of these for any type of hearing that you might have, but especially in a jury trial. These are things that I would recommend. My first recommendation for everyone is take a breath. I guarantee you, when you walk into that courtroom, you are going to be nervous. You're going to get up on the stand and whatever it is, right? Your face might be flushed, your heart might be beating, maybe your hands are shaking, you can't take a breath. It's okay. Again, I've been there. I get nervous too. So I totally understand. But my best advice for everyone is just take a breath and know that your prosecutor is going to be there. We're going to make sure that you have that time to take that breath. So take a minute, get yourself situated on the stand. If you have your chart there, if you're trying to organize your material, do that. And then just let your prosecutor know when you're ready to go. But just keep breathing. It'll be the best advice I can give you. Once you start talking, I always tell people it's okay if you're nervous, and it's okay if the jury can tell that you're nervous. If your voice is shaking, do not stress, okay? It's going to get better. Just work through it. People understand that this is a really stressful environment, and people also understand that you don't do this every day. So the jury's going to totally understand that. So I've had so many people get upset or, really beat themselves up because they're like, oh my gosh, when you started talking to me, my voice was shaking. I couldn't stop my hands from shaking. I messed everything up. No, you didn't. You're human. It's okay. And again, the jury is going to understand that. So just compose yourself as best you can and just know you got this. You're going to be fine. Eye contact. Eye contact is really important. And I actually encourage my witnesses to make eye contact with the jurors. You don't need to make eye contact with me the entire time. I'm not the one that we're trying to convince on this case, right? I'm not the one that needs to hear the evidence. I know the case. So it is totally natural for you to make eye contact with me when I'm asking you the question and maybe we're kind of talking. But if I ask you a question that's going to result in a longer answer, for example, your training and experience, I actually want you to turn and look at the jurors and talk to them. They're the ones, again, that we are talking to. They're the ones that we are educating. And so it is totally fine to look at them and talk to them while you are answering the question. And really, your background and experience type question is the perfect opportunity to do that because you know this. So you don't need to look at a chart. You don't need to try to, read a quotation. This is talking about you. So take that moment to kind of sit back, gather yourself, and then just talk about you. Talk about your education. Talk about your schooling, where you went to school, the things you studied. Talk about your training once you've gotten your job in your occupation. What type of training have you gone through? Have you gone through specialized training? And again, please know your prosecutor is going to be helping walk you through this, but this is what we're going to be talking about, stuff that you know. We're also going to just be talking about your job in general. I always have my SANE nurses talk about not only being a nurse, but what it means to be a SANE. And I will walk them through their training and experience with being a SANE, all of the crazy requirements you guys have to meet to continue to be SANEs, and all of this background and experience type of stuff. But again, you know this. So don't be nervous about these first questions and just know that this is your opportunity to just catch your breath, get comfortable, and talk to those jurors. And I actually tell people to practice that part because again, this is the part that you can control. You know the answer to this question. And as crazy as it might sound, or like as weird as it might kind of feel to do this, practice saying it. As attorneys, we practice our openings, we practice our closings because we want to make sure that we're delivering the message that we want to deliver. So trust me, we all do this. It's not weird. Or if it is weird, then I guess, we're all weird. But please feel free to do this. And I would actually even maybe pull one of your other SANEs aside and just say, hey, can I practice this on you? Does this sound good? Am I saying everything that you think I need to be saying? They're going to be in a great position to help you through that. If they've had to testify in court, they're going to know kind of what people are looking for and what the important things are to talk about. But feel free to practice on your friends, your spouses, your kids, whatever, just ask people like, hey, let me just practice this on you. Tell me what you think. How does it sound? Does it make sense? Like I said, I do that all of the time. So don't worry. The other thing that I would recommend is talk to your prosecutor, especially if it's your first time testifying in court. Tell your prosecutor that. And there's nothing wrong with telling your prosecutor, hey, can I practice that with you? Will you tell me if it sounds okay? Absolutely. I am always happy to do that because I get it. It's weird to have to talk about yourself in court. And so I want to make sure that I am helping you and making you as comfortable as I can. So I will absolutely be available to bounce that off of. So just ask your prosecutor if they're willing to do that. That's another great resource to just practice. But again, just practice reciting it. The more comfortable you get reciting that, the more comfortable it's going to make you on the stand, especially in those first few minutes when the jitters are really going to be bad. So just keep that in mind. And again, you know this. So just tell the jurors all about yourself and all about your training and experience. So then when we actually jump into your testimony and we've gotten past the basics, so we've told the jurors who you are, we've explained to the jurors your training, your education, your experience, then we're going to jump kind of more into the specifics about what it is that you're going to be testifying to. And the way that I've structured this presentation is honestly really the way that I walk my SANEs through their testimony in trial. I would suspect most prosecutors do something very similar. So really, the way we're going to walk through this is probably how your testimony is going to go on the stand. You are going to be asked, what is a SANE? So be prepared to answer that question. You will always be asked that anytime that you are testifying as a SANE in a criminal trial. You will also always be asked, tell me about the general overview of the procedure that you do as a SANE. It's really important for us to be able to explain that to the jury so that they understand just generally what your role in this process is. So this is not specific to the victim. This is not anything specific to the case. You're just going to be asked to explain very generally what a SANE does and just walk us through that process. And what we're going to be asking you to describe are the steps that you take, right? I meet with the patient, I introduce myself, and then I start working through my exam and I do patient history. I'll do a physical exam, and then I'll do the evidence collection, right? And we'll just kind of walk through that step by step. And we'll just make sure that the jury really understands what this process is that you are going through when you are seeing these patients at the hospital. You will always, almost always, be asked how many exams you've completed as a SANE nurse. And again, I always ask exams, both as a SANE and maybe as not a certified SANE. Talk to your prosecutor if you have any concerns about that. But again, I don't want people to worry if you're a new SANE and you're like, man, don't ask me that because I've done like one. So I'm gonna look like an idiot in front of the jury. No, you are not. Absolutely not. Please don't panic. Everyone starts somewhere. And just because maybe you've only done 1 or 2 exams as a SANE, that doesn't mean that you are not qualified to testify to this. You absolutely are. Do not stress. But please make sure you let your prosecutor know if you are a new SANE and maybe you don't have a lot of exams completed yet, just let them know. They'll walk you through how to answer those questions. But really, it's just the general overview. It's all of the stuff that you know. It's the things that you could explain to a friend or family member right now if they came up to you and was like, hey, so what is a SANE and what do you guys do? That's all we're talking about here. That's what we're trying to explain to the jury. Once we've done that sort of general overview for the jury, then we're going to turn to the specifics of the case. And that's when I'm going to then ask you to start referring to your chart, referring to your notes, and that's when we're going to start getting into the specifics of the actual case. So again, I tried to set this up pretty much how I ask questions when we're in trial. And so I always start with, and honestly, I try to just go through your report because I think that's the easiest. I start page 1, and then we just work all the way through your report. But so we're going to start with that initial impressions section. And I'm going to have you talk about, when you got called, how were you asked to become involved in this investigation? Where did you meet the victim or the patient? Tell me about that. What did you observe? At that time, what did you do? Usually it's, you collect the medical history, things like that, right? We're literally going to walk through your report. The one section that I will always, always, always stress with you in trial prep is section 2, the report of the incident. And so as you remember earlier in this presentation, I kind of touched on this a little bit and I said, this is going to be one of the most important parts of your testimony because we are able to have you, the SANE nurse, testify to what that victim told you. In most any other type of case, you would not be able to testify to those statements that that victim made you or made to you, excuse me. So it is so important and so important for the prosecution that we have this exception, because it really helps that victim get their story out there through another witness. And again, you're usually maybe the first or second person that they will be talking to about what actually happened to them. And those descriptions in those, moments or days after the incident are so important. So this is the section of your report that I'm going to ask you to really put the most detail into. Write it down verbatim, write down everything that he or she is able to tell you. And then what's going to happen is when you are in court, when we get to this section of your testimony, I'm actually going to direct you to that section. I'm going to have you explain what you do. And so I'm going to have you say basically that this is the point in the examination where I ask the victim or the patient to tell me what happened. And I'm going to ask you, okay, and do you record that? How do you record that? And you're going to tell the jury that, yes, I do. I actually write it down verbatim. And I'm going to ask you then, do you have that written account in front of you? When you say yes, I'm actually going to have you read it. And I'm going to have you read it word for word. Please know that sometimes there are going to be really uncomfortable things in there that you're going to have to say. The victim might be swearing a lot. The victim might use very vulgar language. And I understand that that is really uncomfortable. But if they use those words to describe the incident to you, I am going to have you read that verbatim. So just be prepared for that. And again, that's going to be one of the most powerful parts of your testimony. So just be ready for that. But again, I don't want anyone to stress, because all you're doing, right, is reading what you've written down. So this is really nothing to worry about, but just be prepared for that. And like I said, I do try to let people know we are going to have to say the words that you might not want to say in a courtroom in front of a judge and jury, but we'll make sure the jury understands that they're not your words, that this is literally what the victim said to you. And then after that, you are probably going to be asked a lot of questions about the victim's demeanor. I usually ask at various points, how are they acting in the beginning? How are they acting at that point in the exam? How about now, right? Because lots of times demeanor changes as these exams go on, because we all know that these exams last for quite a while. So just be prepared to have to talk about the victim's demeanor at various points in your evaluation or your examination of them. You'll go through the interview process, with them, talking through the medical history and any other type of information that you gather with them. And then you're also going to go through your examination. And this can obviously be another really big part of your testimony. It just kind of depends on the case. So if you are doing an exam where you did notice a lot of injuries or physical markings on the body, be prepared to talk about those. And we're going to talk about them one by one. And I mean, I've had exams where I've literally had to say, okay, so we are going to start at the head. And I want you to tell me, what you were observing on the head. And we work our way down to the neck, to the chest. I mean, literally body part by body part. But again, don't worry, because all of this will be in your reports or in your charts. So you'll have the notes. You're going to have all of the diagrams that you've completed that indicate where all of these injuries or these markings were. We're just going to walk through them. One thing that I do try to prepare people for, though, is just know that part of my job as a prosecutor is to really try to break down the evidence. And I try to make it simple and so that anyone can understand it. And so obviously I've run into this a lot with law enforcement. They kind of have their own language, right? I mean, you guys work with law enforcement, some of the words and things that they say. And so lots of times I have to tell them, hey, we're not talking to other cops. We're talking to jurors. So I need you guys to be using regular words, if that makes sense. So same is going to be true with you. I will probably stop you if you are using very medical type words, because honestly, I'm probably not going to know what you're saying. So I'm going to have to clarify, but I can guarantee you our jurors, most of them are not going to know what you are trying to describe if you're describing it in very medical type language. So be prepared for me to stop you and say, oh, okay, hang on. You just used a lot of words that I don't understand. Could you mind telling me what that means? And so again, just be thinking to yourself, how do I describe to someone, a bruise? How do I describe a laceration? How do I describe a scratch? Just little things like that. Again, you should have gone through all of this with your prosecutor before you're actually on the stand. So they should have gone through with you, but bounce ideas off of them and just say, does it make sense if I explain it like this? Do you know what I'm saying if I try to phrase it like this? And we'll get through that part. But just know, this is the part where I usually have to stop my sayings a lot and just kind of break it down a little bit, because we want to make sure the jury's really understanding what we're trying to describe. We will also go through evidence collection. I will say sometimes this might be a really tedious part of your testimony. And that is because if the defense has not stipulated to chain of custody, then that means I'm going to have to go through with you everything that you did with that evidence, right? So not only am I going to have you describe how you collected it, where you collected it from, I'm going to have you describe what you did with it, how you sealed it, who you handed it to, who picked it up, right? All of those things that go into the chain of custody. So just be prepared for that. Lots of times defense attorneys are willing to stipulate to that. And so we can really cut out a lot of that. So we might just focus on what you collected and what part of the body you collected that from, but just know it really depends. So again, those are great questions to ask your prosecutor before you actually take the stand. Hey, am I going to have to testify to chain of custody? What are you expecting me to talk about? Because again, I totally understand that you're only part of that chain for a very small amount of time. So just make sure your prosecutor knows, hey, I was only involved in the collection and then I put it in the envelope and I handed it to this person. After that, I have no idea what happened with it. And that's great. That's all I need to know. Just help me figure out how far in that chain you went, and then I can pick it up from there with the rest of the witnesses. But again, just be prepared to talk about that. And then at the end, you may be asked conclusions or opinions. I'm going to tell you that I don't typically ask this. And that is because there is a lot of case law that is coming out and continues to come out that makes it really dangerous for prosecutors to ask about conclusions and opinions. So my best advice, again, is to talk to your prosecutor. Ask them if they are going to ask you any conclusions or opinions. I suspect most of the time the answer is going to be no. And again, that's for a lot of legal reasons that we have to deal with in court. But it's a really great question to ask, and just make sure that you've talked to the prosecutor about that, and they'll have walked through with you what it is that they're hoping you'll be able to kind of clarify on the stand as far as any conclusions or opinions. But just for what it's worth, I typically, like I said, stay away from that. And my main focus is just to have you explain what a SANE is, what a SANE does, and the specifics of the exam that was completed with our victim for that particular case. That is typically what your testimony is going to consist of. So again, I hope that helps you have confidence, and I hope that helps you feel better, because you're not going to be up there being asked all of these crazy questions. Will it happen? Yes, from time to time it will happen, but for the majority of the time you are testifying to your chart. You can do that. Be confident in that. Do not stress. And so again, these are just things that I remind people. You are the expert. You know your training. You know your experience. You know what you did that night or that morning with that patient. You know your chart. You know your diagrams. Do not doubt yourself. And that is the biggest thing for you to remember while you are testifying. Do not let anyone make you doubt yourself. You know this. You know what you did. You know what you saw. You know what you heard. Just be confident. One thing that I will reiterate a lot when I'm getting my SANEs ready for trial is listen. Listen to the question. Do not ever, 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 under any circumstances, answer a question unless you are really sure you knew what that person was asking you. Because as attorneys, and I am totally guilty of this, sometimes we just start talking because that's what we do. And then before I know it, I've asked this really long, really convoluted question. If you do not understand me, I need you to tell me that. Do not answer that question. Do not try to guess what I was asking you. Ask me. Just say, Ms. Sullivan, I'm really sorry. I don't understand that. Could you rephrase that? Or could you, put it a different way? There is nothing wrong with you doing that. That goes for both the prosecutor and the defense attorney. Do not ever answer a question unless you are absolutely sure you understand what is being asked of you. So sometimes it might be really, you're going to be up there, you're going to be nervous, and you're just going to want to like blurt out the answer because you just want this to be done. You might actually think you know what the question was, but maybe you stopped listening, or maybe you kind of interrupted the attorney because you're like, oh yeah, okay, you're going to ask me about this. I got it. Don't do that. Make sure they finish asking you the question, really listen and think about it, and then answer. I also tell people this isn't like TV. Okay? Nothing about trial is like TV. Unfortunately, it is not fun. It is not suspenseful. It's actually really boring, but it's also not like TV in the sense where you've seen probably those exchanges where the witnesses are just going back and forth with the attorneys and they have all these really great answers. No. Okay. When someone asks you a question, it is absolutely okay to just pause for a moment, take a breath, think about the question, and then answer. You do not have to just rapid fire your answers as soon as the attorney is done talking to you. Please don't do that. It is completely okay. Please don't have like 5-minute pauses. That gets really awkward. But just, take a breath, make sure you actually know what you're being asked to answer, and then go ahead and answer. And again, if you didn't hear a question, if you didn't understand it, or you're just not quite sure what's being asked, please ask for it to be restated. And you can ask that of any attorney, prosecutor, or defense. Cross-examination. I know that this is always very stressful. And this is one of the questions that I get asked the most, is what is the defense attorney going to ask me? What do I have to be prepared for? What are they going to do? Are they going to make me look dumb up there? And I get it. To be honest, it's stressful for me as a prosecutor too, because the answer is, I don't really know. Lots of times I can give you my opinion. I can give you what I think they're going to ask you. And I can also tell you sort of my experiences with that defense attorney. So I will always try to make sure to tell you if I'm like, look, I've worked with this attorney. He or she is actually really nice. They're not going to yell. They're not going to raise their voice. They're going to ask you some questions. Just answer their questions truthfully, but you're going to be fine. I'm also going to give you a heads up though, if it's an attorney that is difficult to work with. If I think that they're going to try to do the whole, yell and point fingers and all that I'm going to tell you that. So again, ask your prosecutors, because I think that's one of the biggest fears, right? Is you just don't know how that defense attorney is going to interact with you. So just ask us, we'll tell you. But just remember, right, the defense attorney's job is to poke holes in the state's case. They're trying to create that reasonable doubt that we talk about with our jurors. So just know that their job is going to be to maybe point out mistakes you've made. Maybe try to point out that maybe, what you just testified to isn't actually, I don't want to say true, but maybe there's another way to explain it, right? And that's fine. So what I tell everyone is just remember, that's what their job is for. So you have to stay calm. One of the worst things that you can do on cross-examination is to get defensive and to get angry and to kind of start like chipping back at that defense attorney, because it's not going to go well for you. And B, a jury's not going to like that. So as frustrating as it is, my best advice for you is to just stay calm. Do not get upset. Do not let them, don't let it show if you're really frustrated with the defense attorney, because again, you are the expert. You are the witness coming in with the specialized training, and you just have to trust that you know what you did, what you saw, and you're going to get through it. What I tell people, hopefully you will have already picked up on it when you've done trial prep with your prosecutor, but you are human. There will be times where maybe you made a mistake on your chart. Maybe you wrote something you didn't mean to write. It happens. It is okay. You do not have to be perfect. And I guarantee you a defense attorney is going to try to point that out on cross and try to get you riled up so that they can discredit you in front of the jury. Do not let that happen. If you made a mistake, own it. Every single one of us makes mistakes. I make mistakes every single day. I make mistakes in every single trial that I do, even though I've been doing this for 14 years. It's going to happen. And all you can do is own it and move on. So if you made a mistake in a chart or something like that, talk it through with your prosecutor before you testify, but then just own it on the stand. The jury's human too. And you know what? They're going to understand that sometimes mistakes happen. And as long as we can acknowledge it, explain it, we're going to work around it. So do not stress about that. And the other thing that I tell people is Don't let them put words in your mouth. So they are going to ask questions that are designed to really kind of push you into a corner because they're allowed to ask you leading questions. So they're going to ask you questions like, but she wasn't crying, right? And you might try to say, well, yes, but, and they're going to cut you off and they're going to say, no, you've answered my question. Thank you. Don't get frustrated. Answer their question, answer it truthfully, and don't get frustrated if you're not able to explain something, because what's going to happen is you're going to see your prosecutor sitting at the table, furiously scribbling notes while you're being cross-examined. Because remember what I told you in the beginning, I'm going to get another opportunity to come back and talk to you once the defense attorney is done. Remember, I kind of said that that's our opportunity to kind of clean up anything that happened on cross. And that's exactly what we're going to do. So once the defense attorney is done talking to you, I get another opportunity. And then I'm going to say, okay, ma'am, I could tell that when you were asked about the victim's demeanor, you were trying to explain why she wasn't crying or why, whatever was happening. And then I'm going to say, would you mind telling us what you were trying to explain? And then you're going to be able to explain the rest of the answer that the defense attorney wouldn't let you. So that is why it is so important to just stay calm. Just remember, you're always going to have an opportunity to come back and explain something if they're not letting you. So don't get defensive. Don't get angry with them. Keep your cool. That is going to play off so well with the jury because the jury is going to trust you if they can see that you're just there to talk about what you did. And you're not making this personal, and you're not trying to pick a fight with the defense attorney. You're just there to tell the jury what happened. Couple of reminders for cross. Again, and this just goes back to the confidence component. You know this stuff inside and out. And honestly, my SANEs testify so much better than most doctors. I mean, I don't know what it is, but doctors, man, I've had such a difficult time with them on the stand, but my SANEs just hit it out of the park. Just remember that. You know this. You know your job. You know what you do in your exams, and you know what you did with this victim. Just stay confident. Another thing that will come up from time to time in your testimony is the defense attorney will try to make it sound like you actually work for the DA, right? Like you're really just, your job is there just to assist law enforcement and to assist the prosecution. So you're really just an arm of the prosecution or law enforcement, right? And I don't want to get into this too much in this particular training because again, this is going to be something that you need to work through with your prosecutor. But just remember, you do not work for the prosecution. You do not work for law enforcement. And so just make sure that you come back to the training that you're receiving here in this training and be able to talk about, no, actually, I don't work for them and here's why, right? Just remember, you don't report to the law enforcement. You don't report to the prosecutor. You're not gathering evidence for the police. Your job is to gather the evidence and observe the evidence that is present or not present and to testify on it. Also point out that you might actually have been subpoenaed prior by a defense attorney. So you testify whenever someone calls you to the stand, whether it's the prosecutor or it's the defense attorney. You're not playing favorites. You show up when someone asks you to show up. That is it. One thing I will tell you that has come up recently in some of my trials is I've had some defense attorneys make a lot of issue about the fact that when you are going through your SANE certification, you meet with the prosecutor. And I've had, like I said, it's only been a couple, but they've started to make the point, well, you don't meet with defense attorneys, do you? And again, if you find yourself being asked those questions, just again, take a breath and be like, no, I don't meet with defense attorneys. And again, hopefully you'll have worked through with your prosecutor on what to say. But what I've been kind of telling my SANEs is remember, you don't come up with the training. Right? You show up at the training and you do what they basically tell you to do. So you're not part of the group that decides the training, but also remember, part of the reason that you meet with the prosecutors as part of your certification is because most of the time we are the ones that are subpoenaing you. So we are the ones that are going to be in the position to kind of talk to you about court, talk to you about what happens in court. And so it just makes sense that you're meeting with the prosecutor during that certification process as opposed to defense counsel. But again, if you're asked those types of questions, just stay calm. You know what your job is. You know why you do your job and just answer it. And just remember, your prosecutor is going to come back. We're going to clean it up if we need to, but don't stress about it. And so really the demeanor slide here that I have just kind of reiterates everything that we've already been talking about. What I tell people, because I kind of want to break this into two parts. I want to talk about your demeanor on the stand, and then I want to kind of jump back to our victim testimony. But let me finish my thought on your demeanor. Your demeanor on the stand is going to be so important because, again, remember, you are there to provide information to the jury. And the way that you do that is by showing confidence and showing the skill that you bring to helping with these types of cases, whether you're there for the prosecutor or the defense. So again, just always keep in mind, the jury is going to be watching you the entire time you're on the stand. So the best way to impress them is to just stay calm, stay cool, and be confident. But let's also jump back to your testimony and talk about demeanor, because you might have noticed that I said there's going to be a lot of questions that I personally, the prosecutor, I'm going to ask you about your patient's demeanor during that exam that you were doing with them. And this is a big thing that comes up in your testimony. And so again, it's going to be really important that you document demeanor throughout your chart. And I've actually encouraged my SANEs, kind of keep jotting yourself notes. Like if the victim initially, when you meet with them and you're going through those initial steps, is sobbing and hysterical, write that down. And then write down if they were able to calm down at a certain point and have a conversation with you. But note they continue to cry, or they continue to have a hard time talking to me, right? Just whatever little things stick out to you, but jot yourself notes and jot them as they're happening in the exam, because that's what's going to help you kind of explain that witness's or that victim's demeanor throughout the entire exam. And the reason that might be so important is because the biggest defense, if you will, that the state runs into in our adult sexual assault cases is consent. I don't want you to worry too much about what that actually means and what the prosecutor is having to prove or disprove, but just know that a lot of the questions that you might get on cross-exam are going to be designed to try to illustrate the defendant's point of, hey, this was all consensual. Like, I don't know why she's saying it was rape or it was forced, because this was all consensual. So the defense attorney is going to ask you a lot of questions that are going to kind of try to help them say, well, see, it is consensual. So be prepared to talk about injuries versus no injuries. And the way I do this is when you are initially testifying, I'm just going to have you testify to what you saw. Were there injuries? Were there no injuries? Great. And we're just going to move through that. Defense attorney is then going to stand up and he's going to make this big point about how, so there were no injuries, right? So she was trying to explain to you that she was, forcibly held down, but yet you didn't see any injuries on her, right? Answer the questions truthfully. And then what's going to happen is I'm going to come back on direct or redirect. I'm going to talk to you about that a little bit though. And I'm going to ask you, so let's talk about injuries. Are injuries or bruises or whatever the case might be, right? Are those always left? Why or why not? If someone is strangled, are there always going to be marks? Why or why not, right? So we're going to have talked through that, and then we're going to explain that on the redirect. So the second time I'm talking to you about anything that the defense tries to bring up. Victim demeanor is going to be one of those because, again, you guys know this better than anyone. Victims all present differently. Some of them are going to be sobbing and hysterical. Others are going to be incredibly stoic and not show any emotion. The defense attorney is going to try to make a big deal about that and be like, so wait a minute. Again, she's trying to tell you that she was forcibly held down and raped, but yet she was not crying at all. She never once got upset. When they ask you those, just answer yes or no. And then I'm going to come back and I'm going to say, okay, let's talk about this. Based on your training and experience, do all victims respond the same to trauma? Do all victims respond the same to, an incident of assault, right? Like, we're going to talk about that. If we have to get into memory, we might talk about that a little bit. But again, these are things that your prosecutor will talk to you about in trial prep so that you are prepared to have to talk about those if we think they're going to come up in trial. Alcohol and drugs is always a big one. If your patient was high, if she was drunk, just say it. We're not here to hide anything. We will deal with that on the prosecution side. But yeah, please don't hide it. If she's drunk, if she's high, whatever, let's just be honest with the jury and we'll just talk about it. And many times, we will have recanting victims. Again, that's not going to necessarily be something that I'm going to ask you as a SANE to talk about, but it might come up, especially if maybe they start kind of recanting during your exam with you, because maybe they start to get a little, just kind of freaked out about the whole process. And then they're like, you know what, never mind, I made this all up, right? So we might talk about it a little bit then if something like that happened. But I mean, I think you could kind of see the defense is going to try to twist a lot of the things that you saw or didn't see in your exam to try to fit this defense of this was all consensual. She's making this up. It wasn't rape. So again, please just answer the questions truthfully. And then your prosecutor is going to come back and we're going to, try to explain anything that we need to explain as far as why some of those things weren't observed or why someone wasn't crying or, whatever the case might be. So I'm almost done. And so in closing, what I just want to say is just remember, I said this at the beginning, I'm going to say it again. Your role in these cases is so important. And I cannot get through some of these prosecutions without my SANEs. You come into court for me so many times. You have been such incredible assets to these victims, and you have really made these cases actually cases that I can prosecute because with your testimony, with your expertise, and just with your service that you perform when you get up there on that stand and you testify and help me educate these juries, you are helping these victims get through this process, regardless of what the verdict is. But just knowing that you're helping them, I can tell you, for example, when I tell our victims that you're going to be there and that you're testifying for them or like about the exam, I mean, I've had some of them just like have these like huge sighs of relief because they're like, oh, okay, good, because I really liked her and she was so helpful that night. And like, I'm so glad the jury's going to hear from her. So just know that you do so much for these cases, but most importantly, you do so much for these victims. So thank you for being here. Thank you for listening to this presentation, but also thank you for being willing to be a SANE. I know that it is such a time commitment. Nobody likes to come to court. I know that is the least favorite part of your job when you sign up for this. But please know how much I appreciate you, how much every prosecutor appreciates you. And so thank you so much for everything that you do.